Hello, and welcome to Industry Insights. My name is David Lennick, and I'm the Associate Legal Editor at Trust and Estates Magazine. I'm joined today by Jean Dorrell, founder of Senior Financial Security. Welcome, Jean.
Good morning.
Jean, what should advisors keep top of mind when it comes to estate planning for clients who are in a same-sex union?
Several things. I've been doing this for 21 years. I'm in one of the largest concentrated retirement communities in Florida. It's called the Villages, and we have a large same-sex population. So I've seen this quite often over the 2 decades I've been working there. And the first thing that comes to mind is, of course, this is their lifelong partner. In many cases, they've been together 20, 30 years. However, they may have had a child in a previous union. And so I always talk to them about, are they including their child, or are they including their partner? Are we going to do percentages? And to make sure that both of those people are covered for estate planning purposes. And so probably the most important thing that comes up right off the bat is, who would you want to make decisions for you if you were sick? Or if you couldn't remember your name for a few months? Would you want your partner, or would you want a child or a family member? 9 times out of 10 they would want their partner. That partner knows what they want and would be the best spokesperson for them. So a lot of times they haven't named that partner. A lot of times they haven't named anyone. So what would happen in that case is that most likely a family member would be appointed to make that decision. So, and that's generally not what they want. So we talk about getting the right documents in place. Also, what I found over the years in looking at this is there are 997 laws passed in our country that benefit traditional married couples that same-sex couples don't have the privilege of enjoying. So it's very important to utilize the laws that are in place to your best benefit when you're in a same-sex situation. Most often with same-sex partners, a lot of times they have the same amount of assets or close to the same amount of assets. Sometimes it's skewed. So when they own a home together, I always ask for the titling of that home to see if they're both joint owners, if only one of them owns the property. And when I see only one owns the property, I immediately ask, did you want your partner to benefit from this if something happens to you? 100% of the time they say yes. So what's nice is there's 15 states, Florida being one of them, where you can actually name anyone to be beneficiary of your real estate when you die. It costs about $20 to do this in the state of Florida. And then when that person passes away, the same-sex partner immediately becomes beneficiary. There's no probate, no cost, delay. They simply file a death certificate at the county.
So Jean, are there any tax ramifications for passing your assets on to a non-spouse?
There can be. Definitely if you're talking about leaving them real estate property for them to enjoy after you're gone. If you were to, say, make that same-sex partner a joint owner, that could be considered a gift. It could be taxable. And so that's not a good idea. Instead, leaving your real estate or your property, your land, your timeshares to your same-sex partner as beneficiary will avoid that at this time under current laws. They would get a step up in basis and not owe any kind of tax situation. Also, there's other things to look for as far as taxes goes when you're talking about IRAs. IRAs, 401ks, you know, these are, I started doing this 21 years ago, so back then people's largest asset was their real estate, their home. Nowadays it's flip-flopped. Real estate values have dropped and IRAs, 401ks are their largest asset. So they have this big tax bomb they're sitting on and they're unlikely to liquidate it before passing away. So if they're leaving that for a same-sex partner, that person cannot do a spousal rollover under current tax laws. They're going to have a taxable event. So there's planning, specific planning that needs to go into place, like possibly doing Roth conversions so that that's a tax-free passover to your same-sex partner, or doing a multi-generational stretch IRA would avoid that for your partner, or even purchasing life insurance. So these are all things that you should be meeting with a certified planner, one who has a lot of experience in overall estate planning, such as myself.
Thank you, Jean.
Thank you.
For more information, visit wealthmanagement.com.